Welcome to Gracefully Graying. I am your host, Attorney Henry Garnvine. Today on Gracefully Graying, I am very pleased to welcome back as my guest, Michigan Supreme Court Chief Justice Bridget McCormack, as we discuss the future of Zoom in our courts and the new normal. And we did an original interview, it was last June to be exact, and we were just in the middle of the pandemic, and Michigan was really ahead of the curve in that they were ready and went to an all Zoom court system. So Chief Justice McCormack, welcome. Why don't you tell us, first of all, what has happened over the years since the pandemic arrived and the courts converted to Zoom? How has it worked so far from your perspective?
Well, first of all, thanks for having me back, and thanks for having this particular conversation. I think it's a really important one that the courts have seen more change in the last 12 months than in the last 12 decades. I'm not exaggerating. I really believe that. And I think that it wouldn't have happened without this pandemic. Obviously, there's nothing good about a pandemic, but the rapid pace of change simply wouldn't have been possible if we weren't forced to figure out how to continue to operate courts and keep people safe. It's, courthouses, as I said, I think the last time I was here, are really busy public spaces where lots of people are forced to be in close contact with one another. And we simply could not do what we normally do and keep people safe during a pandemic. So we made a very rapid transition to the Zoom platform. We had a big advantage here in Michigan because all of the trial judges already had Zoom licenses. They had the software and they had the hardware to be able to make that transition. Most of them had to learn the platform, but to their great credit, they all did it quite quickly. And we have done an awful lot of Zoom hearings. I believe in Michigan, we are nearing 3 million hours of Zoom hearings since we started. And every court in the state is making excellent use of the platform. And as Michigan has ebbed and flowed with its fight against this pandemic, we've been lucky to be able to rely on this ability to continue to allow the public to access justice on the Zoom platform. There have been lots of other innovations we've seen in the wake of the pandemic, but I think these conversations always go better when they're a conversation. So I'll stop right there and see what follow-up questions you have, Henry, instead of me blabbing on and on.
No, this is great. I mean, you're providing us with great information, Chief Justice McCormack. And first of all, what would you say has been the impact on hearings and trials? And I've talked to numerous judges about this, and they love parts of it, don't like other parts of it. So what has it been from your perspective?
Yeah, I mean, obviously not everything we do in courtrooms is done better on the Zoom platform, but a lot of what we do in courtrooms and courthouses is done just fine on the Zoom platform. And for some people, it's a big advantage. So routine scheduling conferences or routine pretrial hearings, even some oral arguments on motions, things where there isn't a significant amount of documentary evidence that has to be introduced that people need to see, people need to handle and see, or judges need to handle and see. Those kinds of things translate quite well, and some we have pretty good evidence are a big advantage to lawyers, and especially litigants, self-represented litigants in particular. So people who had a hard time making it to a physical courthouse because they couldn't get a day off from work, or they didn't have transportation, or they didn't have childcare, have a lot easier time appearing on the Zoom platform because they can do it on their smartphone or their laptop or their iPad from anywhere. They can do it during their break from work in the break room, and that happens regularly. So in a number of jurisdictions across the country, we're seeing sort of a flip in the number of people appearing for some of these routine hearings where they don't have lawyers. A lot of people can't afford lawyers. Eviction cases in particular, there are a number of jurisdictions that are already seeing that the people showing up who have gotten eviction notices is significantly higher on the Zoom platform than it was when we were having those hearings in courthouses. And that's largely due to the fact that it's a lot easier for a lot of people to show up on the Zoom platform. Another example of a place where we've seen a tremendous advantage in using the Zoom platform is hearings where kids are involved. We have repeatedly heard from judges who are presiding over custody cases or abuse and neglect cases, cases where kids are directly involved, and the judges want to be able to talk to those children about what's happening in their lives and in their homes. They report getting far better interaction with kids on the Zoom platform, and it makes sense in a way, right? Courtrooms, courthouses are kind of scary, and that's even true for lawyers. So imagine how true it is for kids who are in a courtroom. On the other hand, talking into your phone on a video feed is quite comfortable for most kids. And so we have judges who say, you know, I have been trying to find out what's going on in this kid's life for many months, and now all of a sudden she wants to show me around her room, she wants to show me her homework, and she's, you know, opening up in ways that we couldn't get her to do in the courtroom. So there are definitely things that we are now doing on the Zoom platform that we will continue to do because there are advantages in doing it that way. Lawyers too, who might have a hearing in Grand Rapids at 9:30 and one in Detroit at 10:30, can now make both of those. That saves their clients money, it saves them time. And so there are definitely advantages to some of the things. Not everything, right? So, you know, jury trials, for example, in Michigan, we have had some judges who have done some voir dire on the Zoom platform because it's one way to do it safely. But then when they have narrowed the veneer to the 12 people who will hear the case, they can bring them into the courtroom and they can spread them out and do it safely. And the lawyers and the litigants prefer that. I will tell you that in other states, Texas in particular, they've had some great success with jury trials on the Zoom platform. I should say it primarily in simpler cases and cases where there isn't a significant amount of evidentiary disagreement, but they've been pleasantly surprised by both the number of people who show up for jury duty on the Zoom platform. Again, like with litigants showing up in court, there are people who have barriers to getting there in person who can get there on the Zoom platform. And lawyers who before the experience were pretty resistant, uniformly after the experience say it went quite well, and they would do it again. So we have not done that in Michigan, but I'm hoping some lawyers will be willing to give it a try.
You know, it's interesting. One of the judges I interviewed, and I've done a lot of interviews with regard to this issue, told me that he tried to get litigants or the attorneys to agree to a Zoom hearing where it was a case where it was a negligence matter, where everything was, liability was admitted, it was just a matter of damages, and the lawyers would not agree to do it.
Yeah, and you know, in Texas, the Texas Supreme Court gave the trial judges the authority to require them to do it, and we have not done that here in Michigan. I'm hoping that we can just get some lawyers willing to give it a try, because, and maybe based on when there's more and more evidence that lawyers in other jurisdictions have tried it and liked it, we might get there. But another tool is giving judges the authority to require it. So.
Let's go through the various courts and talk about where we are. First of all, the district courts.
You know, the district courts are the courts with the highest dockets. You know, district courts in Michigan routinely hear about 3 million cases a year. That's an awful lot of cases. That's where our eviction dockets are, a lot of debt collection, misdemeanors, so high volume dockets in district courts. Right now, most of the courts of the state, because Michigan has a big spike in case numbers, are fully virtual. There are some things that can be and are done in person, but most things are done fully virtually. I think there are some counties that are still, some in the UP and some in northern Michigan, that are doing a little bit better with their COVID numbers right now, and they can do more in person. But those are courts where, because of the very dense dockets in difficult COVID times, it's hard to do much in person.
What about the probate courts, where we're dealing with estates and will contests and mental health issues?
The probate courts can do an awful lot on the remote platform, and in fact, it's one court where there are a number of cases with self-represented litigants and sometimes multiple family members who are, again, this is only anecdotal, we're all trying to collect data about this, but who report that the Zoom platform is quite helpful because people can join from all over, and you might have family members who aren't local who want to be able to, be heard on a probate matter, and it's a convenient platform for much of what the probate courts do. I should say that one other innovation we've been using here in Michigan is the virtual visiting judge. So Milt Mack, who was for a long time the chief probate judge in Wayne County and was then the state court administrator, and continues to be the state court administrator emeritus. He's a great member of our team at the Michigan Supreme Court, but he also serves as a visiting virtual judge in cases where in counties where they need somebody to help with a backlog in the probate dockets because you can do it from anywhere. So it makes the visiting judge work more manageable.
Chief Justice McCormack, now the circuit courts, which would include your family court docket, your criminal docket, and of course your civil docket and business courts. Where are we on those?
The circuit courts are also doing an awful lot by Zoom. And again, our courts are more, the degree to which they're open depends on local health conditions, not as much as dockets. The backup in the circuit courts is jury trials, both civil and criminal. And that's where the big backlog is. Just about everything else the circuit courts have managed to do remotely fairly well, but jury trials is the big backup.
Now, the Court of Appeals, which from my perspective would be an ideal place for Zoom.
Yeah, the Court of Appeals, I don't believe, has lost a step at all. I mean, maybe in the very first month when they were figuring out how to move to the Zoom platform, there might have been a little bit of a lag, but I believe they're fully caught up and they all are working on the Zoom platform. And you're absolutely right. For an appellate argument, it might not be our first choice. I think it's not our first choice. We'd rather be in the courtroom. We have a beautiful courtroom. We all have beautiful appellate courtrooms, but we can absolutely keep up with our workload on a remote platform in a pandemic. There is no problem for an appellate court.
And now your court, the Supreme Court, what are your comments about that?
Same answer for the same reason. Appellate arguments translate just fine to the Zoom platform. There is no reason why we should be behind in our work at all, and we're not. We're current.
Are jury trials in person starting to resume in any courts in Michigan?
Well, we have had jury trials in person over the course of the last year. In times when local health conditions permitted it in a particular local court, they still were using innovations for jury selection. So there were places where juries were picked in high school auditoriums, in ballrooms, in field houses, in a Knights of Columbus hall. And then the trial took place in courthouses. Right now, the COVID numbers statewide are very, very high. And so I don't believe there is any jurisdiction this week conducting jury trials, but we certainly hope that before long, the local conditions permit them again, because we really are determined to get through our backlog.
What have you found the reaction to Zoom from the bench to have been so far?
I've been so proud of the flexibility and resilience that the trial judges have shown all around the state. I mean, imagine managing your docket and doing your job one way for, in some cases, a very long time. And then, on a dime, having to learn a whole new technology, which also means changing everything about what you do. And frankly, I've just been absolutely impressed with our trial judges diving right in and making Michigan a national leader in showing what we can do to continue to keep our courts open. The trial judges have done a tremendous job. I don't think they all love it equally. Some actually like it quite a bit, and some less so. But they've all figured out how to do it, and we have a lot to be proud of.
Chief Justice McCormack, let's fast forward to the future, which hopefully will come sooner than later. Once we return to some type of normal, what do you perceive that will be?
It's hard to say. We have a great work group advising us on this now, because we now have learned so much in these last 12 months that the new normal is not going to be the old normal. You know, the new normal is going to be some combination of remote and in-person proceedings, and we're going to be able to think, you know, more carefully about which resources make the most sense to use. So we can be, you know, thoughtful and determinate about like what things should happen in a courtroom and what things really should happen on a remote platform, and where there's flexibility. So we are actively thinking about that right now. I have Judge Frizard from Wayne County Circuit and Judge Ackert from Kent County Circuit, or Kent County Probate, I should say, leading a task force on making recommendations about how that all should come together, with a lot of, in my view, flexibility for individual judges and lawyers in cases to make decisions that make sense for those cases.
Do you see Zoom conferences and pre-trials becoming the norm in the future?
I would think so. I mean, I'm sure there will be cases where it does not make sense to have them on the Zoom platform, and then they shouldn't have to. I regularly hear from lawyers and judges that those are the kinds of court hearings that absolutely make sense to continue on a remote platform.
What about simple hearings?
I think it's going to depend on the simple hearing. You know, some simple hearings are more simple than other simple hearings, right? But I think that this is where I think we're going to have to allow some flexibility, both for judges and for lawyers and litigants, to make the case that the hearing isn't as simple as it might seem, and might be better off in a courtroom. We're going to have to allow judges to have some flexibility to make some of those determinations.
What about arguments before the Court of Appeals and the Supreme Court? Where do you see that going?
I think it's a great question. I think that for those of us who sit on appellate courts, I think if you asked every judge, we'd say our first choice is in the courtroom. You know, we don't, unlike trial judges, we are not in our courtrooms every day. We only have oral arguments usually 1 week a month. And that's the main thing we do. That's the main thing we do in terms of interacting with lawyers. And so to the extent we can do those in the courtroom, I think all of us will have that preference. I think the lawyers agree. Having said that, there are cases where the remote platform will allow for oral argument by lawyers where otherwise they might not have been able to present those arguments. So some of the indigent criminal appeals and appeals from terminations of parental rights are a couple of examples where, if the lawyers are not compensated for that lawyering, doing it on a remote platform might increase the number of arguments that are able to be made, and that's better. So there'll be some flexibility in appellate courts as well. Same for a lawyer who is out of state or in the UP, and it doesn't make sense for that person to make their way to Lansing or Detroit or Grand Rapids, wherever their argument is. I expect we'll have some flexibility in those cases as well.
Chief Justice McCormack, we've talked about Zoom. Are there any other technological changes that you see coming up in the near future with regard to our court system in Michigan?
Oh yeah, I think Zoom was the easiest and the quickest. I think what we've learned in this last year is that there are lots of ways that technology increases transparency, and it increases access, and it increases efficiency. And lawyers and judges have historically been pretty hesitant to embrace technology, and I think there are lots of interesting reasons for that. But we have resisted the tech revolution as an industry better than maybe any other industry, maybe tied with education. I mean, we've been unbelievably successful at resisting the tech overhaul that happened basically to every other industry in the last 30 years. That's not true anymore. Now, we no longer can resist it. So it's coming for us, just like it came for everybody else. Innovation is percolating all over the place now. Here at the Michigan Supreme Court, we stood up rather quickly statewide online dispute resolution in a platform called MyResolve, and people can access it asynchronously from their smartphones, their laptop. They can resolve cases with or without a mediator. It's absolutely free. They'll never come to court at all. And that's just one of many examples that we're seeing percolating out there. And it's good. It's all for the better.
Chief Justice McCormack, what advice would you give to attorneys about the coming months?
The coming months, I don't think are going to be that different than the last few months. I think the advice is a little bit more, it's more like the coming years. And I think the advice is, this is the most significant disruption we've seen in our industry in my lifetime, in your lifetime, in everybody else's lifetime. I think lawyers need to start thinking like innovators. What are the ways in which we can really approach what it is we do with completely fresh eyes? We always thought there was only one way to do most of what we do, and we learned that wasn't true. What other innovations do you see on the horizon? And how can you think about introducing them? This is just a time of incredible transition, and lawyers who are innovators are going to be leaders.
I want to go into a different topic now, and I find it fascinating because I've been a big believer in podcasts and videocasts, and now you and 3 other Supreme Court justices in other states have started Lady Justice podcasts. Tell us about how that came to be and what's going on with that.
Yeah, it's a fun little project that I do with Justice Rhonda Wood from the Arkansas Supreme Court, Justice Beth Walker from the West Virginia Supreme Court, and Justice Eva Guzman from the Texas Supreme Court. We are, this is a funny backstory, but we got to know each other because of Twitter. I mean, they are all active on Twitter, as am I, and that is how we came to know one another. Although since we have come to know one another online, a number of us have had occasions to meet in person. In fact, Justice Walker has family in Michigan, so she and I have gotten together a number of times when she's been in state. And Justice Guzman and I did a panel together on Twitter and the judiciary in person back before COVID. And the 3 of us have, and the 4 of us have gotten together to produce this podcast once a month, where we take on different topics. And the idea is really just to humanize the judiciary and engage the public in what courts, and in particular state appellate courts, do, which is different from trial courts and different from federal courts in lots of important ways. And we hope to demystify a lot of it. I think the 4 of us are all believers in judges being engaged with the public. That's why we're active on social media, and this is just an extension of that, another way to reach people.
I know you've done about 10 podcasts today. Tell us about some of the topics that you've covered for our viewers.
Yeah, we cover, let me just tell you how we choose our topics. We take turns, and each one of us has, a turn every 4th time coming up with the topic for the podcast, and then what the general questions will be, sometimes even a little more detailed than that, and we rotate. So some of them are what's it like to what's oral argument like, and what are some tips for lawyers in oral argument. Some are, what are the differences in our separate state constitutions with respect to how our courts work and their, the way they make decisions and how things are decided. We've done one recently on women in the profession, which was a lot of fun. And our most recent one, which I don't believe is out yet, is on an issue of all four of us care a lot about, which is mental health and this profession. So big range, and it'll only get bigger because we've gotten through most of the obvious topics. So we'll see what's next. Who knows?
I know you did one that was a tribute to the late Chief Justice Ruth Ginsberg from the Supreme Court, and I think it's wonderful what you're doing.
Well, thank you. It's a lot of fun. It's fun to, honestly, the beauty of federalism is there's a lot of differences between how our courts work and how our judiciaries operate. And I've learned a ton from these three colleagues of mine. It's been a lot of fun.
Before we sign off, I would like you to give us kind of 5 takeaways to summarize what we've been discussing and to share with our viewers, and also for the attorneys in the audience as well.
Yeah, let's see. I don't know if I'll get to 5. I think the takeaways are, there's a top line takeaway, and the top line is we are in a really important moment of transition. And I think there are a number of sub takeaways from that one. That's the main one. That means lawyers and judges don't have to be wedded to how we always approached things. It's time for innovators. And innovators are not usually lawyers and judges, but now all of a sudden they are. We are welcoming innovation in courts and in the practice. And in my view, that kind of innovative perspective is going to help us solve some of the bigger problems that we've all been caring about and circling around for a long time, but have never been able to make disruptive change to. So, for example, the access to justice problem has been one that we've all cared about for a long time, but never been able to make enormous progress towards. 8 out of 10 people in Michigan and probably everywhere else in the country can't afford lawyers for most of their civil legal problems. The answer is not going to be a lawyer for every single one of those civil legal problems, but there are some innovations that now is the time to experiment with. We are going to have to think about regulatory reform. We're going to have to think about upstream solutions to some of our downstream legal problems. And this is an exciting moment to be a lawyer and to be a judge, because I think we can be part of solutions to longstanding structural problems. So roll up your sleeves. Let's get to work.
We're out of time. Chief Justice Bridget McCormack, I want to thank you so much for being our guest on Gracefully Graying. You're always a great person and guest, and I'm a big fan of yours and appreciate all that you're doing. And I want to thank our viewers for watching Gracefully Graying. And again, before we sign off, please go to our YouTube channel to watch this excellent video and the other videos that we have, and also visit our Gracefully Graying site and like us and share us. Thank you so much.
Thank you for having me, and thanks for the conversation.
Thank you.